In this video, we're going to discuss criminal law. Criminal law tends to be one of the more interesting classes that you're going to take your first year of law school. You've probably watched an episode or two of Law and Order, and they tend to produce some pretty fun and interesting fact patterns from the cases that you're going to read in criminal law. I will warn you, however, that criminal law is often a tough class. In addition to looking at some of those fun cases, you're also going to be talking about a lot of different doctrines that may be a little bit complicated and confusing. And another thing that makes criminal law hard is that there are a few different sources of law that crimes can come from. We'll talk about that in just a minute. I want to start by pointing out that in any criminal case, the prosecutor bears the burden of proving that a defendant committed a crime beyond a reasonable doubt. So criminal cases are always initiated by the prosecutor, who comes from or represents the government, brought against an individual defendant. So this is not where one person is suing another person for money damages. Even though you have a victim here, the victim is not a party to the case. It's always the prosecutor versus the defendant. If the victim wants to bring a lawsuit and recover money damages, that's going to be a torts issue. So that's a different class. So in this video, we're just talking about the prosecutor prosecuting a defendant for having committed a crime. And when we say that the prosecutor has to prove every offense beyond a reasonable doubt, let's say, for instance, that the offense the defendant committed has 5 elements. That means that the prosecutor has to prove all 5 of those elements. The defendant doesn't have to prove anything or disprove anything. The defendant can just sit back and wait to see if the prosecutor does his or her job. The defendant simply has to poke holes in the prosecutor's case. So if the prosecutor says, here's my evidence to show that element number 1 has been satisfied, the defendant, when it's their turn, can try to negate that evidence. They can try to show that that evidence isn't reliable, that that evidence is insufficient, but they don't have to prove anything. It's totally on the prosecutor to prove the offense. Now, that does change if the defendant raises an affirmative defense. Like, for instance, if the defendant raises self-defense, then the defendant does have to prove his self-defense claim. He can't just throw out the words self-defense and make the prosecutor prove that he wasn't acting in self-defense. So if he wants to assert some sort of affirmative defense, the defendant would have to prove that. Now, I mentioned that criminal law can be confusing because there's different sources of criminal law. In your criminal law class, you're probably going to cover at a minimum common law and the model penal code. Common law is case law that has given us the various doctrines that make up criminal law. Now, criminal law is a state-specific type of law. So every state has its own set of criminal laws. And every state's criminal laws are a little bit different. So common law is the criminal law that's developed over time, and it may take pieces from different states' laws, but just be aware that it may or may not be applicable in any particular state because that state is going to apply its own very specific criminal code. So you're likely going to cover some common law. The model penal code is a sample criminal code that states can use if they want to, or they can create their own. So it's kind of a hypothetical code of criminal law that varies from the common law. So that's a reason why you're likely going to cover both. You're going to see the common law approach to criminal law and then the model penal code approach to criminal law. So there's a really, really good chance that you're going to cover at least those 2 sources of criminal law, common law and the model penal code. Some schools also do things like include their state's criminal law. So if, for instance, you're taking, if you're going to law school in, let's say, California, you may cover common law and the model penal code and California law. Some states do, or some schools do, and some schools don't. And some schools will point out if there's a state with particularly unique laws They may point to another state's law. So you could look at a lot of different sources of law in your criminal law class. So trying to keep all of those different sources straight and all of those different doctrines straight can be pretty complicated and challenging. Your class will most likely start with some theoretical information that underlies all of criminal law, and this includes the various theories of punishment. Why do we need criminal law? Some of the theories of punishment include utilitarianism. So we have criminal laws to increase the happiness of society by punishing those who break the law. Retributivism, which punishes those who break the law based on what they deserve. So we're punishing them for their bad conduct. And some philosophers follow a mixed approach, which says that we want to punish those people who did something wrong. And at the same time, by punishing them, we hope to increase the happiness of society. We're going to talk next about the various elements of a crime. Now, this doesn't apply to any particular crime. This is for all crimes. So whether we're talking about murder, burglary, bank robbery, larceny, any crime you can think of, all crimes have three main elements. Those elements are the actus reus, or guilty act, mens rea, or guilty mind, and causation. You're probably not going to spend a ton of time on causation. I'll mention it briefly here, but causation is discussed in great length in your torts class. When you get to negligence and torts, I bet you're going to spend a ton of time talking about causation. And so it tends to be kind of glossed over or kind of overlooked in a criminal law class, but it has the same idea. So the same principles of causation that you discuss in torts will similarly apply here in criminal law. So starting with the actus reus, every offense needs a guilty act. Now this could be an act, or sometimes it could be an omission or a failure to act, but either way it has to be voluntary. So for instance, if I'm having a seizure and I accidentally flail my arm in the middle of the seizure and I hit someone else, I didn't commit a battery, because that was not a voluntary act. That was a result of the seizure I was having. But if I see someone and I want to punch them and I pull my arm back and I swing it at them to intentionally hit them, that's a voluntary act. And that could lead to me being convicted of battery. A failure to act or an omission is generally not enough to satisfy this actus reus requirement. There generally is not an affirmative duty to act. So for instance, if someone sees, let's say I see a victim being beat up on the street and I do nothing. I don't step in, I don't call 911, I don't try to stop the attacker from hurting this person. Could I be guilty? Let's say that person ends up dying, the victim ends up dying. Could I be guilty of homicide? Likely not, because I don't have an affirmative duty to step in and act. Now, there are some exceptions to this where there is an affirmative duty to act. We see this come up when there's a contract. So parties have a contract where one promises to act. Think of like a caretaker taking care of an elderly person. They, by contract, promise to jump in and act if something goes wrong. Or if there's a special relationship, like a doctor-patient relationship or a parent-child relationship, a parent has an affirmative duty to act when they see their child in danger. A parent would have to step in, and a parent's failure to step in would likely lead to some criminal charges. Or if there's a statute that requires performance. So if your jurisdiction has some sort of statutory requirement that says you have to step in here, then you would have an affirmative duty to act. But generally speaking, failing to act does not satisfy the actus reus requirement. The mens rea requirement is where we have to see that the person has a guilty mind. We don't punish people for mere accidents, usually. So we want to see here that at the time that they committed this bad act, they did it with a guilty mind. Now, this is where we see a big difference between common law and the Model Penal Code. They have different types of mens reas. So common law recognizes specific intent, general intent, malice, and strict liability. So under common law, you would have to have one of those 4 things, depending on what the crime is, to satisfy the mens rea requirement. Under the Model Penal Code, they recognize purposely, knowingly, recklessly, and negligently as the mental states that satisfy the mens rea requirement. So they could be different here. So it could make a difference if you have a common law crime or a Model Penal Code crime, because they might require a different mental state for the exact same crime. We're going to go through these and talk about these various mental states in a little bit more detail. Let's start with the common law mental states. And first, we're going to talk about specific intent. For a specific intent crime, the defendant has to intend a specific result. So for instance, first-degree murder is a specific intent crime. A defendant will only be guilty of first-degree murder if the defendant specifically intends to kill the other person. So you couldn't have a first-degree murder in a situation where the defendant accidentally killed the victim, because there was no intent to cause that particular result there. So it can't be a specific intent crime. General intent crimes are where the defendant is generally aware of what he's doing and generally aware that his conduct will cause a particular result, even if he doesn't intend that result. A great example of this is battery. So a defendant might be, let's say, swinging a baseball bat, and he knows that the victim is standing nearby, and he means to just scare the victim. He didn't mean to hit the victim. It wasn't his intent to hit the victim with the baseball bat, but the defendant swings the bat, and the baseball bat grazes the victim and hits the victim. That would still be enough to satisfy the mental requirement for battery. Because even though the defendant didn't intend to hit the victim, his conduct should have led him to believe or know that this result could likely occur. So that would satisfy the general intent requirement. For a malice crime, the mental state is satisfied if the defendant acts recklessly or intentionally disregards a known risk. A malice crime, for instance, would be arson. So if a defendant, let's say, strikes a match and throws it toward a building and the building catches fire and burns down, throwing matches toward a building is pretty reckless. So even if the defendant didn't intend to burn the building down, under common law arson, that defendant would still be guilty of arson. And then finally, we have strict liability offenses. For strict liability offenses, no mental state is required. So regardless of what's going on in the defendant's head, if the defendant does the act, the mental state is also satisfied. We use this for very small offenses, like regulatory offenses. Think of speeding, for instance. If you're driving your car and you're speeding and you get pulled over, and you tell the police officer, "I'm really sorry, I didn't realize I was speeding," it doesn't matter. Regardless of what was going on in your head, you did the act, you went over the speed limit, so you're guilty of that crime. You're going to get a ticket. Another strict liability offense is statutory rape. In many jurisdictions, an adult who has sex with a minor is guilty of statutory rape, regardless of whether he or she knew that the minor was actually under the age of 18. The mental state is irrelevant as long as the act occurs. Under the Model Penal Code, as I said, we have some slightly different mental states. The first one we have is purposely. Under Model Penal Code purposely, the prosecutor would have to show that the defendant's conscious object is to engage in specific conduct. So the defendant's purpose is to achieve a particular result. This is very similar to common law specific intent. There's a lot of overlap between these two. The next one under the Model Penal Code is knowingly. Here, the defendant is aware that he's acting in a certain way or that his conduct is very likely to cause a certain result. This one is very similar to common law general intent. Third, we have recklessly. So under Model Penal Code recklessly, the defendant is consciously disregarding a substantial and unjustifiable risk. Very similar to common law malice. And then finally, we have negligently. Common law doesn't recognize this as a mental state, but under the Model Penal Code, if a person knows or should have known of a substantial and unjustifiable risk, and they choose to deviate from the reasonable standard of care that should be exercised here, some Model Penal Code crimes, negligence crimes, would find that conduct to be criminal. Now, the actual crimes themselves will fall into one of these categories. So you'll have the crime, and one of the elements of the crime will be one of these different categories of mental states. So it's not a pick your favorite here where you decide what mental state to apply. For instance, if the crime is first-degree murder, that requires specific intent. Specific intent is an element of first-degree murder. If the crime is battery, that's a general intent crime. So general intent is one of the elements of battery. So this is just a list of all the possible mental states that you could encounter. But know that when you look at the particular crime and the elements of that particular crime, that crime will have one of these mental states as a required element to satisfy that offense. So we have the actus reus, or the guilty act. Then we have the mens rea, or the guilty mind. And then third, we have causation. I mentioned that this is covered in more depth in torts, but just to briefly cover causation here, there are two types of causation. You have to have both of them, and they're actual cause and proximate cause. Actual cause looks to see that the defendant's conduct is a cause in fact of the result. So for instance, if I push my friend into oncoming traffic and my friend gets hit by a car and dies, my push is the actual cause of my friend's death. Now, the driver driving there is also an actual cause of my friend's death. So that's where proximate cause comes in. Lots of different things could be the actual cause. Proximate cause looks to see whether the event should have foreseen, or the person who acted should have foreseen the resulting harm as a result of the conduct. So as a result of me pushing my friend, should I have been able to foresee that they were going to be hit by an oncoming car? So if I push my friend into an open field and some random cow comes out of nowhere and tramples my friend, that likely isn't foreseeable, depending on the circumstances. But pushing my friend into a busy road where there's traffic coming, it is foreseeable there that he or she could get hit by a car and that the death could result. So you have to have both. You have to be the actual cause and the proximate cause of the person's harm. The last piece under causation is what we call the concurrence principle. The concurrence principle really links the guilty act and the guilty mind. And this is almost always present. It's not usually an issue. There are some offenses where we see it as an issue. Burglary is a great example of this. Burglary is breaking and entering into the dwelling of another at night with the intent to commit a felony therein. So you break into someone's house intending to, let's say, steal something once you get inside. According to the concurrence principle, the intent to steal has to be present in the person's mind at the time of the breaking and entering. The intent to steal is the guilty mind. The breaking and entering is the guilty act. They have to be occurring simultaneously to satisfy the concurrence principle. So for instance, if a homeless person is breaking into someone's house, not to steal anything, but just to stay warm, they don't have the intent to commit a felony inside. So they don't have the right guilty mind to have completed a burglary. The burglary requires intent to commit a felony once they're in. So if this person doesn't intend to commit a felony at the time that they're breaking and entering, there's no burglary. Even if they decide they get inside and they're like, wow, that's a nice TV, I'm going to steal it. They weren't thinking that at the time that they broke into the house, so no concurrence. So most of the time, as you can probably imagine, the guilty act and the guilty mind are clearly linked. But once in a while, you have these crimes where there could be a situation where you have a guilty act at a different time from the required guilty mind. All right, now we're going to talk about some defenses that a defendant could raise. And there's 3 categories of defenses. Failure of proof defenses, which argue that the prosecutor cannot prove one or more elements of the offense. Justification defenses, where the defendant is saying, yes, I did it, but my conduct was justified. And excuse defenses, which say, yes, I did it, but my conduct should be excused. It wasn't criminal conduct because of some excuse. So your defenses generally fall into these 3 categories. Starting with the failure of proof defenses, the classic failure of proof defense is mistake of fact. So the defendant will argue that there was some mistake of fact, typically that negates the mens rea of a specific intent crime. That's the only time that mistake of fact will work, is if it is a specific intent crime. Then it will be a defense as long as the mistake is in good faith. So for instance, arson under common law is not a specific intent crime. It's a malice crime. So if a person is mistaken as to whether this match was actually going to light or not, and they lit the match and they threw it, and then they thought to themselves or said out loud, I had no idea that was going to happen. That's not a defense to arson because they were still pretty reckless. By striking the match, throwing it at the building, that's still reckless conduct. But you'll notice the People v. Navarro case. This case involved larceny, which is a specific intent crime. And the defendant stole some beams that he thought had been abandoned. He thought that these beams were just out for trash. They're free for the taking. Turns out that they were not abandoned beams. So in the defendant's mind, he's taking what's free for taking. He is not thinking to himself, I'm going to take this other person's property and use it for myself. He didn't have the specific intent to take someone else's stuff. He thought that what he was doing was perfectly fine. So that mistake of fact as to whether or not those beams were abandoned did negate the mental state, the mens rea required for larceny, and therefore the defendant is not guilty of larceny. So the prosecutor would be unable to prove the mental requirement of that offense. Mistake of law is generally not a defense. So saying that I didn't know that that was illegal generally won't help the defendant. That won't work as a defense. There's a few very narrow exceptions to that rule where mistake of law can be a defense. The justification defenses, as I said, are where the defendant says, yes, I did that, but I had a reason. I was justified in my action. The first one is self-defense. So the defendant is saying, yes, let's say, committed the murder, but I was justified because I thought that person was about to attack me. So the rule for deadly force in self-defense is that the defendant is allowed to use deadly force if he reasonably believes that he is facing a threat of imminent death or serious bodily harm. So if someone is walking toward me with a gun and it's pointed and they say, I'm about to shoot you, I could pull out my own gun and shoot them. And if I was charged with murder for having shot and killed this other person, I can claim self-defense. I can say I reasonably believed, since there was a gun pointed at my face, that this person was just about to attack me. So I had to act in self-defense to protect myself. This generally doesn't work if the defendant is the initial aggressor. So if a defendant starts a fight and then the other person escalates the fight or engages in the fight, and then the defendant says, oh my goodness, now I have to act in self-defense. They can't do that. They can't start the fight and then claim self-defense. So you can't be the initial aggressor. You can be the initial aggressor and possibly still get to claim self-defense if the other person escalates the fight to deadly force, or if the person who started the fight withdraws from the fight and then the other person continues the fight. So like if I start a fight with someone and then I walk away, I go inside my house, I shut the door, and they barge into my house and they pull out a gun. And now they're inside my house. They escalated it. I also withdrew and they continued it. So now I could act in self-defense and claim that it was reasonably necessary. Under common law, in order to use self-defense, one has to be able to show that they could not have safely retreated. In other words, if you're out in the middle of the street and someone is coming toward you, you have to try to retreat from the situation before you're able to resort to using deadly force in self-defense. Many states now have enacted stand your ground laws that say you don't have to retreat. You can stand your ground and use self-defense without retreating. The next justification defense that we have is defense of property. A person can use non-deadly force to defend their property, not deadly force. So in this particular case, the People v. Cabello's case, there was a man, he was going to be away from his property for some time. I don't know if he was going on a trip or he was just going off somewhere for a few days. Well, he didn't want anyone to come into his house while he was gone. So he set up a spring-loaded shotgun that would go off if anyone tried to break in. So if someone opened his door, they would get shot. Remember, he's not home. So he's just doing this to defend his property, his house. And the court said no. If that person, the intruder, ended up dying, the homeowner there would be guilty of some sort of homicide offense because you can't use deadly force to protect your property. If the man had been home at the time and there was an intruder and he is protecting not only his property but also himself, that's a different story. But you can't use deadly force to just protect your property. The third one is necessity. This is where the defendant reasonably believes that his conduct is necessary to prevent a greater harm. The classic necessity example is that there is a wildfire coming toward a neighborhood. So a defendant burns down the houses at the edge of the neighborhood to stop the fire from spreading, because if there's nothing left to burn by the time the wildfire gets to the neighborhood, the fire will stop and it won't continue to the rest of the houses in the neighborhood. So if that defendant was charged with arson, the defendant could say it was necessary to burn those houses down in order to save the rest of the houses in the neighborhood. The defendant says, I did this for the greater good. This typically doesn't work for murder. It's very hard to say that it was necessary to commit a murder to prevent greater harm or to protect the greater good, unless you're using some sort of self-defense or defense of others claim. The third category of defenses is excuse defenses. So here the defendant is saying, yes, I did it, but my mind wasn't right. I wasn't in the right mindset. I didn't have a guilty mind at the time that I committed the offense. The three excuse defenses are intoxication, insanity, and duress. Starting with intoxication. When a defendant tries to raise intoxication as a defense, they don't have a very good shot at raising voluntary intoxication. It's going to be very difficult for a defendant to say, I sat back, I drank a bunch of beers, I got really drunk, and then I went out and committed a crime, but I shouldn't be guilty of that crime because I was really drunk. That doesn't work great as a defense. Involuntary intoxication, though, has a little bit better chance of working as a defense if the defendant can show that he was coerced into becoming intoxicated. So someone injected or involuntarily poured alcohol down a person's throat, or made an innocent mistake. They didn't realize that what they were ingesting was intoxicating. Or if they took some intoxicating substance pursuant to medical advice and they were not aware that it was intoxicating. So if my doctor prescribes me a medication that has a side effect of making me incredibly intoxicated, but he failed to tell me that fact. So I take it, I get in my car, I go out and I commit a crime. I can raise involuntary intoxication as a defense and argue that I didn't have a guilty mind. I was acting under the influence of this intoxicating substance. Now, voluntary intoxication can work sometimes if it negates the specific intent of a specific intent crime. Now, I'll give you an example though, because this doesn't mean that the person is necessarily off the hook completely. So let's say, for instance, that two friends are at a bar and they're playing darts, and one friend says, you should go stand in front of the dartboard. I have such a good shot. I will hit it right above your head. I'll take a hair off your head, and that's it. And the other friend says, that's funny. That's a great idea. And they're both drunk. And so the one friend throws the dart, hits the friend in the face, and let's say the friend ends up dying. Now, we're going to talk about homicide in a couple minutes, but murder requires the intent to kill. First-degree murder is a specific intent crime. The defendant must intend to kill the victim. So clearly here, the drunk friend did not intend to kill his other friend, but that doesn't mean he's necessarily off the hook completely. Second-degree murder is a reckless crime where the defendant simply acts recklessly. This sounds pretty reckless. So the intoxication would negate the first-degree murder charge, but it wouldn't help the defendant if the defendant was charged with second-degree murder. So the defendant's not off the hook completely, even though he's raising intoxication as a defense. Under the insanity defense, there's a few different tests that a court may use. Some courts use the M'Naughton test, under which the defendant has to show that he suffered a disease of the mind that caused a defect of reason. That's really hard to show. That's a high standard for the defendant to meet, to show that he has a disease of the mind. And then as a result of that disease, the defendant has to show that he lacked an ability to know the wrongfulness of his actions or to understand the nature and quality of his actions. So this is a tough test to meet. So we don't see defendants all the time raising the insanity defense because this is a very, very high standard. The M'Naughton test is probably the hardest insanity test to prove. Some jurisdictions follow a slightly less strict insanity defense. Some follow, for instance, the irresistible impulse test, where the defendant simply has to show that he was unable to control his actions or unable to conform his conduct to the law. He doesn't have to show that really hard disease of the mind here. He just has to show one of these two things. The Model Penal Code says that the defendant has to show that he lacks substantial capacity to either appreciate the criminality of his conduct or conform his conduct to the law. So this one too is a little bit lower standard that's a little bit easier for the defendant to meet. So it just depends on the jurisdiction and which test the particular jurisdiction has adopted. The final excuse defense that we have is duress. This is where the defendant acts in response to a reasonable fear that if he doesn't perform, either he or another person will suffer imminent death or serious bodily harm. So for instance, if I'm driving my car and I'm stopped at a red light and someone hops into my car and holds a gun to my head and says, take me to the bank, we're going to rob a bank, and I have a gun being held to my head, I'm probably going to drive that person to the bank. So if I was charged with, let's say, bank robbery for helping this person rob the bank, I could raise duress as a defense. Because remember, for the excuse defenses, we're looking at situations where the defendant isn't morally blameworthy. They don't have a criminal mindset. I'm not trying to commit a crime here. I'm trying to save my life and not get shot by this person who's holding a gun to my head. So certain defenses go with certain crimes, which can make this tricky. Then that's why it's helpful to have a good understanding of the different mens reas, because as we saw with some of the defenses, sometimes they only apply to things like specific intent crimes. So knowing what a specific intent crime is helps you see if the particular defense here could apply to that crime. Turning to the next page of the handout, at the top of the next page, the first thing we're going to talk about here is inchoate crimes. Inchoate crimes are incomplete crimes. So the crime itself, the result, didn't actually happen. So think of murder, for instance. The person didn't actually die, but the defendant may have still done something. That's where inchoate crimes step in. So just because the victim didn't die doesn't mean that the defendant should be off the hook. But because the defendant has done something toward the completion of the crime, we may turn to the inchoate crimes and hold the defendant responsible for something else. There are 3 inchoate crimes. The first one is attempt. So let's say the defendant holds up a gun, points the gun, shoots the gun, but misses the victim. It is very likely that that defendant will be guilty of attempted murder. So for attempt, the prosecutor would have to show, first of all, a guilty act. And here the requirement is that the prosecutor show that the defendant had the specific intent to complete the crime. So did the defendant intend to commit a murder? The actus reus has a couple different approaches for attempt. A majority of courts follow the substantial step test, in which case the prosecutor has to show that the defendant took a substantial step, strongly corroborative of a criminal purpose. So in this instance, thinking about committing the crime isn't enough. It's not enough to just decide that you're going to commit a crime. But going out and getting the gun, driving to the victim's house, pulling out the gun and aiming it, that's a pretty substantial step. And so that would likely be enough for attempted murder. Under the common law says that the act must come dangerously close to commission of the crime. So under common law, let's say buying a gun, getting in the car and starting to drive toward the defendant's house or to the victim's house might be a substantial step, but it probably isn't dangerously close. So this is where the 2 tests would make a difference. That conduct might be attempted murder in a majority state, but might not be attempted murder in a common law state because the defendant there is not dangerously close to committing the crime. Now, attempt merges with the completed offense. So think about murder, for instance. Let's say a defendant buys a gun, gets in his car, drives toward the victim's house, pulls out the gun, aims the gun at the victim. At this point, the defendant has most likely committed attempted murder. If we stop the action right there, we have an attempted murder. So if the defendant actually shoots and kills the victim, now we have a completed murder. This merger doctrine says that the defendant can't be guilty of both attempted murder and completed murder. Once the crime is completed, the attempt merges into the completed offense. The second inchoate offense we have is conspiracy. A conspiracy is an agreement between 2 or more people to commit a crime. So the mental state required is the specific intent to enter the agreement and to accomplish its objectives. So let's say, for instance, I want to rob a bank. And I turn to my friend and I say, I've decided to rob a bank. I need some help. Will you help me? Will you be my getaway driver? I will split the money with you. And my friend says, absolutely, I'll help you rob the bank. Well, my friend and I have the intent to enter into an agreement and the intent to accomplish its objectives, to actually rob the bank. The actus reus requirement is satisfied by the agreement, so entering into the agreement, and some states require an overt act. So some states would say the minute my friend and I agreed to rob the bank, we're guilty of conspiracy. In other states, we would have to make the agreement and then do something else. Like let's say we purchase our car, our getaway car. So we have the agreement plus the act, the purchasing the car. So that, again, it depends on the jurisdiction and what rule they follow to see what would satisfy the actus reus requirement. Now, unlike attempt, conspiracy does not merge. So if we agree to rob the bank and then we get this car, we get in the car, we go to the bank, we rob the bank, we're going to be guilty of bank robbery and conspiracy. Conspiracy is its own crime and it does not merge with the completed offense. The reason for this, or a good way to remember this, is that the law wants to punish people who agree to commit crimes. If you can find another person who thinks like you do and is in agreement with you to commit this crime, the law is going to punish that even more than just one person individually committing a crime. So those two people are going to be guilty of the crime and conspiracy to commit a crime. The third inchoate offense is solicitation. And you can think of solicitation as being like the first half of a conspiracy. So when I go to my friend and I say, hey, would you like to help me rob a bank? I am soliciting my friend to help me rob the bank. So even if my friend says no, even if my friend never responds, the fact that I asked my friend to commit the crime is a solicitation. Now, solicitation merges, meaning that if my friend says, yes, I'll help you, and now we have the agreement, I wouldn't be guilty of solicitation and conspiracy. The solicitation would merge into the conspiracy. Or let's say I hire someone to commit a murder for me, and they go out and they actually commit the murder. I could be guilty of solicitation or the completed murder, but not both. So solicitation merges. So of the inchoate offenses, conspiracy is the only one that does not merge. Conspiracy is its own offense. Solicitation is an offense unless it's completed, in which case it merges with the completed offense. An attempt merges with the completed offense also if it is completed. In the next box, you'll see that the defenses to these inchoate offenses are limited. The two common defenses are impossibility and abandonment. Impossibility is not a great defense, though, so arguing that it's factually impossible to have completed the offense generally will not work as an offense. Legal impossibility typically is, so saying that the offense, had it been completed, is not a crime, will work as a defense. Some jurisdictions recognize abandonment as a defense. So before the offense is completed, if the defendants say, you know what, we changed our minds, we're not going to do this, some jurisdictions would say, okay, because you changed your minds, you abandoned the whole thing, you're not guilty of anything. The next section is on accomplice liability. And the number one mistake that I see people make with accomplice liability is that they call it its own offense. So I'll give you a hypothetical. Let's say, for instance, I'm going to burn my neighbor's house down. I have a huge feud with my neighbor. I'm going to get some matches and burn their house down. So my friends are over hanging out at my house and I say, hey guys, I'm going to go burn my neighbor's house down. Does anyone have some matches? And one of my friends hands me some matches. And I take the matches and I go burn the house down. I am guilty of arson. My friend who handed me the matches is guilty of arson, not accomplice liability. Accomplice liability is a theory under which the helper, the accomplice, is liable for the exact same offense as the principal. In reality, what we typically see is that accomplice is given some sort of deal or plea bargain. They're allowed to plead guilty to a lesser offense. And so they're not usually guilty of the same offense as the principal, but they could be. Theoretically, they could be guilty of the same offense. So that's important to keep in mind. So the parties to a crime are the principal. In my hypo, that was me, the person who committed the crime, and the accomplice. That's the person who provides assistance or encouragement. For accomplice liability, the accomplice has to have the intent that the principal commit the offense. So if I just said, hey, I want to light a candle, does anyone have some matches? And my friend hands me some matches, which I then take and go use to burn down my neighbor's house, my friend is not an accomplice to my arson. But if my friend either knows or intends to help me commit the arson, then that would likely satisfy the mens rea requirement. And then the actus reus is satisfied if the defendant provides some sort of physical assistance, like gives me the matches, or encourages me. So mere encouragement could be enough. So if I said to my friends, I have been feuding with my neighbors, they're driving me crazy, you know what, I should burn their house down. And my friend says, that's a great idea, go burn that house down. That encouragement makes my friend an accomplice. All right, so if you've noticed up to this point, we haven't really talked about any actual offenses. I've mentioned a few of them, but we haven't looked at them in detail. And this is pretty typical in a first-year criminal law class. You're going to talk about a lot of different doctrines and theories and pieces of crimes in general, but typically not a lot of actual crimes. The one crime that you're most likely going to talk about is homicide. So to give you an overview of homicide and the different degrees and types of homicide, we're going to walk through this chart here. So homicide can be broken really into two parts, murder and manslaughter. Murder includes first degree, second degree, and felony murder. And then manslaughter includes voluntary and involuntary manslaughter. Now, these are common law designations. Under the Model Penal Code, the Model Penal Code recognizes murder and manslaughter, but doesn't really break it down into degrees or types of manslaughter. But commonly, homicide is broken down under the common law into degrees and then voluntary and involuntary for manslaughter. So let's start with murder. Let's talk first about murder. So the definition of murder is causing the death of another human being with malice aforethought. And notice that malice aforethought is bolded. So what constitutes malice aforethought is going to dictate whether we have first degree or second degree murder. And this is where we see the mental state, the required mental state. What is going on in the defendant's mind is going to help dictate what type of murder it is. So for first degree murder, this is an intentional killing of another human being with premeditation and deliberation. So that means for first degree murder, the malice aforethought has to be premeditation and deliberation. Premeditation and deliberation means that the defendant thought about it and made a decision to commit the murder in advance. So think of like a cold-blooded killing. That would definitely be a first-degree murder. Second-degree murder still requires malice, but not necessarily premeditation or deliberation. So there's a few different mental states that could satisfy the malice aforethought requirement for second-degree murder. So this could include things like extreme recklessness. So if, for instance, a defendant walks into a crowded shopping mall and shoots a gun, doesn't intend to hit anyone, but a bullet ricochets off the wall and strikes a victim, and the victim dies. That defendant acted recklessly. That would satisfy the malice requirement, and that would be second-degree murder. Malice is also satisfied for second-degree murder if the defendant acts with intent to cause great bodily harm and death results. So let's say the defendant doesn't intend to kill the victim. The defendant just means to, let's say, torture or harm the victim. So they cut the victim's leg off. But the victim ends up bleeding out and dying. That satisfies the malice requirement. That would be second-degree murder. And then the third mental state that satisfies malice for second-degree murder is where there's intent to kill, but not quite premeditation and deliberation. So this is typically where the defendant acts impulsively, but doesn't have a justifiable excuse, which we'll talk about in just a couple minutes. For felony murder, this crime occurs where you have a death that occurs during the commission of another felony or a flight from a felony. So here the mental state is simply the intent to commit the felony. There doesn't have to be any type of intent to commit the murder or to commit a homicide. It's simply the intent to commit a felony, and the murder resulted, the death resulted. The act requirement is satisfied simply by the felony. As long as the felony occurs and then the murder or the death results, the defendant can be guilty of felony murder. Now, there are some limits to this. So not just any death that occurs in the course of a felony will satisfy felony murder. For instance, it has to be an inherently dangerous felony. Something like arson, rape, kidnapping. If you have one of those and a death results, that's inherently dangerous. On the other hand, if I'm committing tax fraud and I'm at my accountant's office and my accountant happens to have a heart attack and dies in the middle of my committing tax fraud is not inherently dangerous, so it would not be a good underlying offense for felony murder. The second limitation is the merger rule. This says that the underlying felony can't be something where the defendant intends to cause harm. If a defendant is acting, let's say, swinging a baseball bat, intending to hit the victim, and the victim does get hit and ends up dying, the act, the swinging the bat, which is likely a battery, merges with the death, and that person's just going to be guilty of some degree of murder. First degree, second degree, manslaughter, but not felony murder. So the felony has to be something where the intent of the felony is not to harm or to kill. So something like burglary, the intent is to break in and steal. Arson, the intent is to burn down a house. Those work for felony murder, but assaultive crimes do not. The third limitation is the causation rule. This is applicable when someone other than the defendant, the felon, causes the death. So let's say, for instance, a defendant is robbing a bank and the police show up and the police shoot their gun toward the defendant, trying to stop the defendant, but they miss the defendant and they end up striking and killing a bank teller. So the defendant didn't shoot and kill the bank teller, the police did. So whether that defendant could be liable for felony murder depends on the jurisdiction. Some jurisdictions follow the agency theory, which says that felony murder does not apply if the person who caused the death is a non-felon. So here the police officer caused the death, so the bank robber would not be on the hook for felony murder. However, under the proximate cause theory, the defendant is guilty of felony murder as long as the defendant set in motion the events that ended up causing the death. So by doing the bank robbery, they caused the police to show up, caused the police to fire the gun, and thus caused the bank teller to die. So under an agency theory, the bank robber would not be guilty of felony murder, but under a proximate cause theory, the bank robber would be guilty of felony murder. Under the Model Penal Code for felony murder, they simply say that committing the felony that results in the death of another person simply gives a presumption that the mens rea for murder is satisfied. So they don't really see it as its own offense. It just makes it a little bit easier for the prosecutor to prove murder under the Model Penal Code. So then if it's not a murder, our other option is manslaughter. So manslaughter is causing the death of another human being without malice aforethought. So you don't need that malice for manslaughter. You don't need the premeditation and deliberation. You don't need the extreme recklessness. You don't need the intent to commit serious bodily harm. So voluntary manslaughter occurs if you have an intentional killing. So it's an intentional act to kill another person, but it's done in the heat of passion due to adequate provocation. Classic example of voluntary manslaughter is a spouse walks in on his or her spouse cheating in bed with another person, instantly pulls out a gun, instantly kills both the spouse and the other person. Now that person, the defendant, would be probably guilty of voluntary manslaughter because they were acting in the heat of passion. They walked in, they saw this, they were instantly enraged, and this was due to adequate provocation. This is the type of thing that would provoke a reasonable person. Most people would get pretty upset about this kind of thing. So they did it in the heat of passion and they were adequately provoked. Now, they're not off the hook completely. This doesn't mean that they were justified in their conduct. The benefit to them here is that they're guilty of manslaughter, which is a lesser offense than murder. So they're not likely going to be guilty of some sort of first or second degree murder, but they're still guilty of manslaughter. Whether the person acted in the heat of passion is looked at from an objective and subjective standard, meaning that this person was actually subjectively enraged and a reasonable person would have been actually enraged. Same thing for adequate provocation. We want to make sure the defendant was actually provoked and a reasonable person would have been actually provoked by this. Finally, we have involuntary manslaughter. This occurs where you have a killing that is due to gross negligence or recklessness, not extreme recklessness. Remember the person who walked into the crowded shopping area and fired their gun, that's extremely reckless. This is a little bit less than that. Gross negligence or just recklessness, and satisfies the requirements for involuntary manslaughter. This can come up if there's some sort of failure to act in a situation where there is a duty to act, such as if a parent has a sick child and fails to take their sick child to the doctor and the child ends up dying. That's likely gross negligence for failing to take your sick child to the doctor, so that could be considered involuntary manslaughter. Now, as I said when we started homicide, you're probably not going to cover too many specific crimes. Some of the other crimes that you may or may not discuss are listed down below here: assault, larceny, burglary, robbery. Another thing to keep in mind is that a lot of these crimes are also torts. So you're going to talk about some of these in more detail in your torts class. You'll talk about assault and battery and things like that. And what is the tort result? So there can be some overlap here, and you're likely going to go into more detail discussing the elements of those various offenses in torts. In criminal law, there's a good chance you'll just talk about homicide, maybe a few other crimes, but you're going to spend a lot of your time going over those general principles of criminal law. So I hope you find criminal law enjoyable. As I said, it tends to be more difficult than you may think, but some of the cases are actually really interesting to read because they often include some fun fact patterns.